In April, the Treasury Department's Office of Foreign Assets Control, or OFAC, made an announcement about COVID-19. And initially, financial institutions were very excited. They were excited that OFAC was acknowledging that the virus was having a severe impact on the ability of those institutions to comply with the sanctions regime. But after a while, they started to wonder, what exactly did that announcement mean? So let's take a look at the announcement and discuss how it can be helpful for financial institutions. So this is going to enrage our marketing staff, but I'm going to just read to you what OFAC said. It's just one sentence. They said, if a business facing technical and resource challenges caused by the COVID-19 pandemic chooses, as part of its risk-based approach to sanctions compliance, to account for such challenges by temporarily reallocating sanctions compliance resources consistent with that approach, OFAC will evaluate this as a factor in determining the appropriate administrative response to an apparent violation that occurs during this period. Okay, so OFAC writes very long sentences, but basically what they're saying is that they expect financial institutions to reallocate some resources during the pandemic from sanctions work to other parts of the bank. This statement actually didn't change any of the applicable standards that apply to regulated financial institutions. In fact, it explicitly said the same risk-based standard that was announced in previous guidance still applies. So banks are asking, did it create any new legal rights at all? And the answer is no, it didn't. It doesn't create any new legal rights. And the relevant legal question is, if a regulator comes after the bank and accuses the bank of having violated the regulations promulgated under OFAC, does this new announcement create any new rights in the bank that the bank can use to stop the regulator from initiating that answer? And the answer is no, it doesn't. They still can seek penalties from the bank if they choose to do so. Just because the Treasury Department didn't create an entirely new legal standard for evaluating whether or not a financial institution has violated OFAC or regulations under OFAC, that doesn't mean that this new statement is useless. In fact, it can benefit a bank in a number of ways. First of all, it's an acknowledgement that under some circumstances, it's appropriate for a bank to reallocate resources from sanctions work to other types of work during the pandemic. Second, examiners are trying to be reasonable. And so to the extent that there's a disagreement over whether or not a reallocation was appropriate, they're going to look at the statement just like the bank will to evaluate whether or not that was appropriate. And that would come up both if the regulator was determining whether or not to downgrade the bank when it was creating, for example, a CAMELS rating, or if it was thinking about imposing a penalty on the bank. And third, even if a regulator were to come forward and try to seek a penalty on a financial institution, there's an intra-agency appeals process that the financial institution can use to get the agency to reconsider bringing that. And so this statement would be an excellent foundation for an intra-agency appeal. If you're interested in learning more about intra-agency appeals, I actually created a video on that for the Institute for International Bankers. And I will create a link to that video when I post this. What should banks take away from all of this? Well, they should consider during the pandemic reallocating resources from sanctions to other parts of the bank, but they should do so with caution. If Kim Jong-un calls and asks for a payment protection program loan to be wired to him, you probably should talk to your compliance officer before you send that out. And if you already sent it out, you should call me. I'd be happy to talk about any sanctions compliance questions that you have.